Nous sommes en audience publique, Monsieur le Président.
We are in public session, Your Honor.
Mr. Keegan-Cartwright, you mind if I ask this witness this question?
Mr. President, I don't mind you asking it.
Witness, you've heard the portion of the document, the portion of your statement that counsel read out when we were just in private session. You have also seen the document that the discussion concerns. The question is this: in your opinion, or according to you, are you saying the document is genuine or not genuine? Or are you saying it is official or not official? What are you saying?
Not genuine.
Thank you.
Lastly, Mr. Witness, you have no recollection of any journalist having been in that session because it never took place, isn't it, Mr. Witness?
I have a recollection.
Mr. Witness, the only reason why you can recollect only Mr. Sang and you have pulled in Mr. Nimrod Tapu now is because if you weren't going to say the name of Mr. Sang, you would have lost relevance for the prosecution, isn't it, Mr. Witness?
No.
Mr. President, that should be all from me. Thank you, Mr. President.
Thank you. And you have 5 minutes left.
I can carry it forward, Mr. President.
No, do not. Prosecutor, did you say you have questions in re-examination, and how much time do you expect doing that in?
Your Honors, my questions are very brief. I think in the space of about 10, possibly 15 minutes. Of course, it depends on the responses. But I don't anticipate going over 20 minutes.
It's not always the witness's question, responsibility. Sometimes questions themselves can cause a witness to respond the way they do. But you can proceed.
And the entirety of my questions will be in private session. Yeah.
We'll then go into private session. Thank you. Witness, we've come to the end of your testimony, and I wish to thank you especially for coming to assist us with our inquiry into what happened in the wake of the Kenya elections in 2007. We know that the experience has been difficult, not only because you had to travel far to come, but also because lawyers do ask these questions that sometimes the average witness is wondering, what is this all about? And sometimes wondering whether this is not just there to abuse you. That wasn't the case. All the lawyers asking you questions are doing their work, and we thank you for doing yours in helping to come and answer those questions. We wish you good luck as you travel back. Thank you. We will bring down the blinds and then escort the witness out of the courtroom.
Nous sommes en audience publique, Monsieur le Président.
We are in public session, Your Honor.
Prosecutor, the next witness is 189, is that it?
Morning, Your Honors, that's correct. Yes.
while we wait for the witness to be brought in, we will attend to a certain ruling of the chamber. The ruling is in relation to witness protection measure on the stand. In the chamber's decision of the 3rd of September 2013, the chamber deferred its ruling on protective measure in the courtroom. The chamber required both the prosecution and the victims and witnesses unit to provide additional information and updated information that will help in the assessment of the needs of the witness for protection in the courtroom. In particular, in light of any views expressed by the witness upon arrival at The Hague. The prosecution was directed to consult with the Victims and Witnesses Unit and, where appropriate, to notify the witness of this pending application upon arrival. The Victims and Witnesses Unit was asked to transmit to the chamber the witnesses' views as well as the unit's own updated information on the witness's security and psychological well-being. On the 9th of October 2013, the unit sent its security assessment to the chamber. In the assessment, the unit recommended the usual menu. Usual is not supposed to trivialize or routinize the measures, but in particular, the unit recommended image and voice distortion, the use of pseudonyms, limited private sessions, and redaction to public records where necessary to prevent identification. Having considered the recommendation of the unit, the chamber hereby grants the request for protection measures in the courtroom to the extent recommended by the Victims and Witnesses Unit. That is to say, image and voice distortion, use of pseudonym, redaction to public records, and limited private sessions where there's a risk that the testimony may be of a unique nature which may, as such, reveal the identity of the witness to the wider public. That is the chamber's ruling.
Your Honors, it's always an estimate, obviously. I predict that, depending on how the witness testifies, it should take no more than a day and a half of examination in chief.
Try and make it less than that. Also, have you advised the witness of the obligation?
Yes, Your Honor, the obligation to tell the truth and the fact that there is a criminal offense of perjuring yourself, not saying the truth while testifying, has been stated to the witness, and the witness states she understands that.
I know I have not asked you this question in the past, but you should also make it part of the preparation, the requirements of Rule 74 about the need. I think personally it's an odd thing to have to tell a witness coming, but the rules indicate that it needs to happen, about self-incrimination, the right to object when questions might lead to self-incrimination. Did you happen to do that as well?
No, Your Honors, we did not do that. I know there's a list of witnesses that would be concerned by this rule against self-incrimination, and clearly we will do that for those witnesses who are deemed to be insiders.
Right. Do that outside the courtroom alongside the reminder of the obligation to tell the truth and the perjury thing.
Indeed, Your Honor.
And that also goes for the defense. When it's your turn, it's best to do these things before the witnesses come in.
Your Honour, for the defence, we actually tell witnesses at the time we speak to them. We don't leave it so late. Your Honour, given what my learned friend has said, we intend to give any material we would use in cross-examination by about 2:30 today.
Thank you. Mr. Naratsetse, is this a witness of interest to you from the perspective of victims?
Mr. President, if you allow me, I'll consult my colleague for a few minutes.
Well, you can do that later. All right. You don't have to do it immediately, but in the course of the prosecution, some examination in chief, you can let us know.
I'm grateful, yeah. Thank you.
We will now bring down the blinds and lead the witness onto the stand.